Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Now, without any further ado, it's my great pleasure to introduce our speakers today. I'm going to go roughly in the order that they will be joining the conversation. So starting with Jennifer Magnes. Jennifer is a senior partner and co-managing partner at White, Zuckerman, Warsawski, Luna and Hunt LLP, where she specializes in forensic accounting and litigation support in family law matters. A CPA with ABV credentials, she brings over 2 decades of expertise in business valuation, asset tracing, and support analysis. Jennifer has testified across California and contributed to hundreds of complex marital dissolution cases. She's also a seasoned instructor, having taught MCLE and law school courses on valuation and tax issues. Her practical insights have made her a trusted resource for attorneys and the courts alike. She came very highly recommended from several of our Southern California jurists, and she also contributed to our additional handout materials today with an excellent business valuation overview and cheat sheet. So I encourage you to take a look at that later on. Thank you for joining us today, Jennifer.
Thank you.
Our next speaker is Judge Leslie Landau. Judge Landau joined ADR Services, Inc. in 2023 after 20 years of distinguished service as a judge of the Superior Court in the County of Contra Costa. The last nearly 10 years of her tenure on the bench focused on family law, culminating in her term as supervising judge of the Family Court in 2022 to 2023, where she made pivotal contributions to the court's technological advances and response to the COVID-19 crisis. Judge Landau has been recognized by the legal community for being hardworking, a deep legal thinker, a quick study, human, and fair. She anticipates issues, particularly in complex custody and business disputes, assisting parties in managing potential pitfalls and crafting decisions that account for them. And in 2023, she was honored as Trial Judge of the Year by the Alameda Contra Costa Trial Lawyers Association, or the ACCTLA. Thanks for being with us today, Judge Landau.
Great to be here.
And our final speaker, last but certainly not least, is Judge Stephen Pulido. With over 4 decades in the legal profession, Judge Pulido has developed a deep expertise in family law, having handled complex disputes involving high asset divorces, custody battles, and intricate support and property division issues. As a practicing family law attorney for 28 years and then a Superior Court judge for 18, he became a trusted authority in managing emotionally charged cases with fairness, pragmatism, and a deep understanding of the law. His leadership as presiding judge and supervising judge in family law allowed him to refine court procedures, facilitate settlements, and ensure efficient case management while prioritizing the well-being of families. Now, as a neutral, he draws on his vast experience to help parties navigate difficult legal and personal challenges, offering clear, results-driven guidance in mediation and in private judging. His ability to balance legal precision with practical solutions make him an invaluable resource for resolving even the most contentious family law disputes. We appreciate you being here, Judge Pulido.
Great to be here.
Great. Now, I will quit yammering at you all, fade into the background, and hand it over to Jennifer to get us started with some business valuation overviews.
Good afternoon, everybody. So yeah, we're here to talk about business valuations. And I think as many of us know, there's many type of businesses that we come across when we're dealing with family law, from personal services to retail, restaurants, manufacturing, import, export. And appraising businesses can be the most financially impactful issue in most of our cases. So when you're hiring an appraiser, the appraiser is going to need to look at the business as a going concern to determine if there's any goodwill. So I just said a lot of words and a lot of terminology that probably didn't make a whole lot of sense to a lot of people. So I'm going to define a little bit of that for you. What does going concern mean? So when you hear an accountant use the term going concern, what they're saying is that a business entity is going to continue to operate and exist for the foreseeable future, meaning that company is not going to be liquidated. It's not going to be forced out of business. It's going to be financially stable enough to meet its obligations as they become due in the ordinary course of business. So that's a very key concern when we're doing the business appraisals, to make sure that we're looking at a business that's going to continue. What's goodwill? If you're looking at the Business and Professional Code, goodwill of a business is the expectation of continued public patronage, so that it's going to continue going forward, it's going to continue getting customers. The NIC, the National Association of Certified Valuators and Analysts, also define goodwill as an intangible asset arising as a result of name, reputation, customer loyalty, location, products, and similar factors that aren't specifically identified. So in layman's terms, goodwill is the ability to earn superior earnings due to the reputation, location, and all of those factors that a business had as compared with other similar businesses. It's the likelihood that customers are going to continue to patronize a business as opposed to another business. Mathematically, the value of goodwill is the value of the business that exceeds its net asset value. So the assets less the debts. Basically, this is the intangible value of the company. If the appraisal is less than net book value, then there's probably a problem with the appraisal, right? So goodwill is only the intangible. It's the part over and above net book value. So if your appraiser is coming up with something less than net book value, then there's probably an error in their report. Before any work commences by an accountant, there needs to be clear scope. And that scope is set by counsel. Counsel needs to provide the appraiser with any legal arguments. That's your date of value. Are there breach of fiduciary duty claims? Are there separate property claims? All of that would need to be identified by the attorney to the appraiser so that the scope is clearly defined. And then the CPA is probably going to ask for information. In order to appraise the company, there's going to need to be probably discovery, maybe significant discovery, demands for production, special interrogatories, depositions. Your forensic will probably provide you with a doc request and possibly an appraisal questionnaire. I did provide some examples of that in the materials, and I know we're going to talk about more of that as we get further into this. But all of this information is to assist the appraiser, and that way the appraiser has all the relevant data to render conclusions. And from there, the appraiser can determine which approaches are most appropriate for this specific business. And we're going to discuss those various approaches shortly. And Katie, if we could move to the next slide. Thank you. So when we're appraising an asset, any asset, there's many standards of value that the appraiser can rely upon. In family law, you typically hear fair market value or investment value, and they are very different. So to understand the differences, fair market value requires three specific facets to exist, and they all have to exist for the standard to apply. The three factors are what the asset would sell for on the open market with a willing buyer and a willing seller, with neither being under any compulsion to buy or sell, and with both sides having reasonable knowledge of the relevant facts. Again, all three of these factors must be true for the standard to apply, and none of those are true in family law. So in family law, we're typically using investment value, which is sometimes referred to as marital value. And there are some cases that discuss that, and I believe the cases are listed in some of the materials that you received. But this standard represents the value of the asset to a specific owner. So it's considering the owner's perspective, the owner's knowledge, the owner's abilities, what the owner's expectations of risk and earning potential are, and other factors. So this is appraising the business from the perspective of how this specific owner operates, because there's no sale contemplated. So now we're going to talk about the approaches, and a lot of this seems very detailed and very nuanced, but I always liken this to real estate appraisals. I think most attorneys are used to reading real estate appraisers. The approaches are not actually any different. So all appraisers are looking at these approaches, right? All appraisers actually must consider all three approaches. They just don't have to use them all, but they have to consider them all when rendering their conclusions. So when you look at a real estate appraisal, you're seeing an income approach, you're seeing a cost approach, and you're seeing a market approach. And then that appraiser is sort of reconciling them to come out with their conclusions. The same thing is happening with a business. So when we are appraising a business, we're using the same approaches, we're just probably looking at different data and information. So what are the three approaches? And what are the methodologies within them? We start with the income approach. This approach estimates the business value by considering ongoing benefit streams. Sometimes that's using EBITDA, sometimes that's normalizing cash flow or other earnings, and applying what we would call a cap rate, sometimes referred to as a multiple, which is based on the risks associated with the business. The income approach does not take into account the net assets of the company. So this is not always applicable to all companies. So when doing the income approach, the common methodologies are the discounted cash flows, which is not typically a family law approach because that requires projections into the future and some speculation. Typically in family law for the income approach, you're going to see capitalized cash flows or capitalized earnings. That's what's most common. When we're looking at the cost or asset approach, you're estimating the business value by considering the net book value of all assets, all debts of the company, plus goodwill. So you still have to calculate something here. Often in family law, we're accomplishing this using excess earnings. I think we always hear that terminology a lot. Excess earnings is actually a hybrid method between the income and the cost approach, but it is the most commonly used. Similar to the income approach, we are applying a cap rate, a multiple, to an earning stream of some sort, whether it's EBITDA or it's a normalized earnings of some sort. The difference here is it's going to take into consideration the net assets of the company. And so the cap rate that we're using under a cost or asset approach is not going to be the same as an income approach if there are significant assets. If there are not significant tangible assets, the risk should be about the same, right? Because that's really the differential here. We're carving out the risk associated with assets that are tangible versus intangible. And intangible assets are typically much more risky. So we're trying to carve out some separation between tangible and intangible risk. The market approach is comparing similar businesses sold in the market, private or public, to our subject business. And then we're using multiples or ratios that are derived from those transactions to our subject company. And again, if you're likening this to a real estate appraiser, that's probably what most people are looking at the most, sales comps, right? You're looking at what's been sold, how do they compare, and then trying to somehow delineate the value of this entity, this business, from some other business that was already sold on the market. And this is based on various databases, again, public or private. And most forensics subscribe to multiple databases, which is really good. You would want to see as much as you can. If we have multiple databases and they're all converging and they're all coming up with about the same, it's not going to be exactly the same, but close to the same number, it's a good sanity check to make sure that there's no outliers that are skewing the data. So these are the three approaches that are really taken into account when you're appraising a business. Now, when to choose which valuation approach? Again, you have to consider all three. So it should be noted in your appraiser's report that they did consider all three, and then there should be some explanation of why they chose what they did. So the appraiser should have a good understanding or an explanation of why they excluded something. It's not just why you included, but why you excluded. And as previously discussed, there can be many methods within the three approaches, and they might use more than one method. So for example, under the market approach, you might use three different databases. That's using three different approaches to that, three different methodologies to that one approach. And when using more than one method, and when using more than one approach, there should be convergence. You don't want to see that under the market approach, you have a $10 million valuation, and under the cost approach, you have a $2 million valuation. There's probably an error somewhere in there, or something's not applicable because there's some skewing of data. So there's got to be some convergence in the conclusions to have validity. To the extent the conclusion of value rendered exceeds the net book value of the company, meaning the assets less the debts, if there's more value than what that tangible value is worth, then there's goodwill. And if there is not, then the net book value is really the value of the company. So when are the methods appropriate? So for the income approach, probably applicable for companies with minimal tangible assets, because again, it's not factoring in any rate of return or any of the risk related to those tangibles. The cost asset approach is applied commonly to companies that have more than minimal tangible assets. It's most commonly used in family law. It's the most one that you'll see happening in our family law appraisals. And again, if there's no goodwill, this approach is still utilized because it's showing net book value. It just won't have a goodwill component. The market approach is also very common, especially in companies when there is a lot of available data that's available. Not always true for all of our companies, especially if we're dealing with companies that are not typically sold, which does happen in family law. And we also use the market approach often when we don't have a lot of reliable financial data. We can do this because let's say all we know is the gross receipts of a company. The books are not very good. We're not really sure about the profitability. We're not really sure about the expenses, but we know the gross receipts. We can probably get a multiple from a list of database based on gross receipts of the company sold and what that multiple was applied to those. It's not a perfect value, but it is a data set that you can use if nothing else is available. So this is something that will provide you with an estimate where maybe you couldn't do it under the income approach because you do need to have a stream, a benefit stream. So sometimes the market approach is just used if you just need to get an estimate, maybe for settlement. The cons with the market approach is that when you're looking at the comps, you need to make sure that the comps are actually comparable. And that can be very difficult with companies, especially with the databases that we are mostly using. They don't always provide all of the data for these companies. Sometimes, we don't know the company names typically. We might know the industry, we might know some of their background, but we don't have a ton of information available. So we want to make sure that we're using actual comparable companies. We don't know all the factors maybe that were in the sale. Was there a non-compete? Were there some synergies that were part of the sale, merger and acquisition? Was there some other facet that was integrated into the sale? Were they renting the space from the seller and they gave them a discount because they got a good rate on something? So you don't know all of the pieces of the sale. You just know basic sale information. So you want to make sure that you can do the best you can to look into the comps and get them as close as you can possibly get them. You also want to make sure that there's not skewed data. So if you only have 2 or 3 data points in your database, you may not be seeing what's actually comparable in the industry. So there may be anomalies in there. And so you may need to disregard the market approach. Regardless of which approach is taken, the appraisals are only as good as the underlying information utilized and the assumptions built into the appraisals. So you as the attorney are going to want to make sure you understand all the strengths and all the weaknesses of the report. The expert's going to need to make sure that their report aligns with all the legal arguments that you're going to make. For example, are there arguments of celebrity goodwill? Are there arguments of separate property? What's the contributing factor for the growth? Are you going to do Prayer? Are you going to do Van Camp? You want to make sure that your forensic report is jiving with all of your arguments. Do you need a reasonable compensation expert for additional data? Are you going to need to get some other experts to talk about the industry? What arguments are you going to see yourself putting forth? I think communicating with the forensic is key to making sure that the reports align with all the arguments and that there is actual sufficient data to support the arguments.
Judge Landau, I see you talking, but you have mute on. I know that you were going to talk on here.
Oops. Okay, sorry about that. There are challenges in business valuation in all cases, and particularly in family law cases, because often the businesses are small businesses. And so you have problem or businesses that are owned with a few other people that are not part of the community, relatives or partners or other co-owners. Or maybe the in-spouse, the person who is involved in the business, is somebody who is a partner, say, in a law firm or an accounting firm or something like that, and they own a small piece of a very large business. And so one of the problems you have is document availability and privacy. And availability, sometimes if it's a small business, their records will be terrible. A small business that is operating on a very small margin may not have the money to pay accountants to keep good records, or they may not particularly want to keep good records. They may have a lot of cash that comes in and out that they don't necessarily even deposit. They may pay personal expenses for the families of the partners. I'm going to say partners, but it's regardless of the corporate form. They may run them through the company. They may use their personal credit cards to purchase things for the company. So sometimes getting the records and trying to figure out what's really going on is itself a tremendous challenge. There's also the issue of cooperation of colleagues, because colleagues are not necessarily going to want to have their business, their own personal business delved into. I mean, sure, you can. I'm wondering, Katie, can you pull up the list in Jennifer's written materials of the documents that are being requested? In your written materials, here you go. So this is the list of documents required for business valuation. Just scroll through that, Katie. I mean, that's a lot of documents. Keep scrolling. It keeps going and going and going. And there's all these questions, all these documents. And honestly, the partners who are not getting divorced are not going to want to spend money or time pulling that stuff together. And they may resent the outspouse digging into their personal finances and exposing the underbelly of their business. And particularly if the colleagues are sort of family friends and they don't particularly want, the in-spouse's best buddy with whom he or she runs the business may not want the outspouse to know that he's got a girlfriend on the payroll, or that there are contingent liabilities like lawsuits pending or threatened litigation for sexual harassment or malpractice, or that other person not in this marriage is using business expenditures to buy, I don't know, hookers and cocaine. They don't want anybody knowing these things. And so you have to be really careful. And subpoenaing these things can actually, or demanding too much, can risk damaging the in-spouse's business relationships in the valuation process, and could lead to the ouster of that in-spouse if the structure allows it. So you have to be kind of careful, and you have to be aware of the minefields. And yes, you can have a protective order, but a protective order doesn't necessarily address all of these personal issues. You also have to make sure that the valuation suits the business type. I mean, for example, if you have a family business that's a dry cleaner, that's really different from a law practice. Nobody cares who is going to clean the clothes at the dry cleaner. What they care about is that the dry cleaner will have the clothes, will clean them well, will not damage them, will have them available, and are friendly. That's all they care about. But a law practice, they really want somebody, the clients are going to want it, not just any lawyer. They are picking a lawyer because of particular talents, because of particular expertise. And so the valuation method you choose for a commodity business like a dry cleaner is not going to be the same as the one that you choose for a specialized practice like a law practice. And you want to make sure that you are being sensitive to market factors and future predictions. I mean, how do you account for market factors when you're picking, for example, a multiplier? How immune is this business to market fluctuations? For example, real estate. Real estate, there you can have downturns in the market. You can have issues with insurability, which affects the ability to sell the property. We all know about that in California right now. There's a real insurance crisis. Interest rates are going to affect what the market can bear, because the more interest people pay, the less they can borrow. And you need to also predict the future of the business. What's competition? What's going to be the cost of goods, consumer needs, disruption from technological advancement or obsolescence? Look, for example, today, if you have a small business that is retail and mostly sells toys from China, you've suddenly got the potential effect of tariffs, which is going to affect the availability of goods and the cost of goods, and then the prices of goods. And interest rates, inflation, that's going to affect the business as well. And then there are some businesses that are countercyclical. For example, when business is booming, a bankruptcy lawyer is not going to be very busy. But when business cycle is down, that's when a bankruptcy lawyer's practice is going to be robust. And so you have to when you're valuing a business, be aware of all of these intangibles that could affect the multiplier in the future of the business. And finally, you have to think about the assumptions about the in-spouse's work life. How long is this in-spouse going to work? My experience in family law is that these business valuation issues tend to arise when people have reached a certain age. They are not the young people, by and large, who have the businesses that are successful. It's people who've been at it for 20, 25, 30 years. They're in their 50s, they're in their 60s. And then the parties separate, and then the question arises, well, how long is that 58-year-old going to continue in this business? Are they going to continue in it for 5 years? How about the 68-year-old? I've had cases where I had a 68-year-old lawyer, and the expert was assuming that 68-year-old lawyer would work for another 5 years. Well, how reasonable is that expectation? So you have to really be sensitive to the issues that arise in family law. So let's go on to the next slide. So here's some examples of the nature of the business. We talked already about the dry cleaner versus the law practice. But then there's the issue of a professional practice like the law practice. The in-spouse is entitled to the value of their work. That's not necessarily something that you consider. Therefore, you have to look at the excess earnings. How do you parse the excess earnings above the average earnings that somebody like that would be paid? Well, it's difficult. You have to find a similarly situated professional. How do you do that? There are data sets you can find, but you have to be very careful. You can't, for example, compare a big law partner with 20 years experience in mergers and acquisitions in an international firm with a family law practitioner in Lodi. They may both be lawyers, but their income expectations and what a similarly situated professional would make, and therefore what their excess earnings are above that, very difficult to do, but you have to be aware of it. And you also have to account for those market factors. We talked about the problem with the market factors and how you account for those, but you have to be aware of them. Then there's the assumptions about the work-life expectancy. We talked about that. And then, one of the problems is garbage in, garbage out. This is what Jennifer was talking about. If your data is not good, your outcome's not going to be good. If you don't have good data going in, if you don't have good accounting records, if you don't have good assumptions, what you're going to come out with is not going to be useful. And as lawyers, one of the important things to do, you can't just assume, well, the expert is the expert and here's the number. Because if the expert hasn't had that communication with you about what it is you really need in the case, that report may not track at all an accurate number. And I've had certainly a lot of cases, both as a judge and in mediation, where there has not been good enough communication between the expert and the lawyer. And so the report is effectively useless because it's speaking to something that assumes things that really don't apply in the case. Then there's the prediction of the future of the business. This is really important because we have this expectation that businesses are fixed and what exists will always exist, but it is so not true. Anybody who remembers the ad campaign, "This is not your father's Oldsmobile," think about that. Oldsmobile, when I was growing up, was one of the big U.S. manufacturers. There are no Oldsmobiles anymore. And that ad campaign, "This is not your father's Oldsmobile," was sort of this sad harkening back in an attempt to revitalize a brand that was on the way out. And all you have to do is look around you. I mean, you had Blockbuster and Netflix. Both of them were in similar businesses, providing CDs for use when you wanted to watch a movie. Blockbuster is gone. Netflix reinvented itself and is in everybody's TV at home. One died, one exploded. But it was the same original business. So what was the future going to hold? What would an expert be able to predict? Look at document review and how young lawyers used to be retained for hours and hours to do document review. And now with AI, it's a totally different business model. And all you got to do is look at that phone, which you're probably looking at right now because you're not interested enough in this. But look at your phone. Every function on that phone was once a separate business. There used to be businesses that made planners and calendars and cameras and music players and clocks and watches and newspapers and notepads and books. And now they're all on your phone. And so you have to, when you're doing a business valuation, you have to be mindful of the disruptive effects of all kinds of future events. Businesses change based on things outside the owner's control. And when you're talking either to a court or mediation about the value of a business, you have to be sensitive to that potential for change because you're projecting about goodwill, about future earnings. And what do you do when experts disagree? Well, the first thing that you should do is have the experts talk to each other. If you have two experts and they've come to really different resolutions, it's real important to have them talk to each other. And I don't know if Jennifer has anything else to add on that point, but it's kind of an important issue because it happens a lot that you have real discrepancies between the valuations. And what do you do then in mediation? What do you do in trial?
Yeah, I think the first step is always to set up a side-by-side of the two reports because appraisals are part art, part science. So there's going to be actual factual data that's going into these reports, and are there differences there? Because those are really something that shouldn't exist. You should be able to discuss facts and they should align. Or are the differences from the subjectivity that's built into these appraisers? And if it's from the subjectivity, you're talking about all these things that you just raised, right? What is the risk of this company? What is the ability of this company to keep going in the future? And while we aren't allowed to project and we aren't allowed to speculate and we can't do any of those things in family law, we can't really look at projections. We do want to consider what's going on in the industry. So we do want to have a good understanding of why we feel, under our opinion, subjectively, that there is more risk to this company or less risk to this company. How do we support that data? But the only way you can figure out where the differences are is to first start with the side-by-sides. See, really pinpoint, is it the cap rate that's different and what in the cap rate is different? Did they do a build-up method? Are they showing how they got there? Is it from the comps they're using? Is someone using, a comp in Florida or a comp in Iowa versus all the comps being in California for a California entity? Are they using something in a small town versus a big city? So it's really pinpointing, where is the data stemming from? Why are there differences? If they're subjective, is there some rationale behind it? Because no two appraisals should ever be the same. There's too much subjectivity built into them. There's never going to be similar, an exact number coming out of two different experts. But there should be some range of reasonableness that they fall into. And when they don't fall into that range of reasonableness, that's when you know there's some discrepancy that needs to be discussed.
Okay, let's go on to the next slide.
All right, that would be me. In family law, you have some very specific challenges when you're valuing business. The first is the timing of evaluation. And I first refer you to Family Code Section 2552, which says that the valuation normally, or not even normally, it just says shall take place at a time that is closest to the time of trial. And that is the rule that applies in business valuations in family law. However, and here's where the complications arise. Section B of Family Code Section 2552 says that upon 30 days notice by the moving party to the other party, that the request can be made that the court value the business on a date somewhere between the date of separation and date of trial. And there has to be good cause shown. So let's break that down a little bit. First of all, the 30-day notice, this is something when I practice and as a judge.
Well, we're having a moment of backup.
We're having a moment.
Yes, hold on.
It's that a formal notice.
Oh, Judge
motion.
Pulido, we lost you for just a moment.
Okay.
Can you go back maybe 10 seconds?
Yes, I was says my internet is unstable. There we go. I'm going to go back. The 30-day notice motion, there's a 30-day requirement of a notice to the other side. You're going to seek an alternate valuation date. And it's not required that it be a formal motion. Although I will advise you all that it would be best practice in my book to have a formal notice motion. The case of in marriage of Janice, Jnes, excuse me, does say that you can just give written notice, but you got to be clear on your written notice. It has to indicate what's the date you're selecting or proposing, what's the legal authority for that notice and request, and what's the good cause. So that has to do with the 30-day notice. Now, the big gist here is what's good cause? And there's many, many cases out there that deal with good cause. It would take forever right now to go through that. We don't have that. But one of the biggest reasons that we value a business as of the date of separation is if there is a business where the operating spouse's efforts, his skill or her skill, her work is in fact a key factor in whether a business goes up or down since the date of separation. So those businesses, like a law practice, a dental practice, I've had many dental practices in my time on the bench, any kind of small business, there's the bee business you probably have all heard about in the Stevenson case, construction businesses. Those almost have a finite reason to do those businesses on the date of separation. So that's good cause. Other cases you'll see about good cause for valuing a business other than date of trial is if there's been some manipulation of income, some misconduct of the operating spouse after separation. We'll talk more about that in a little bit. Sometimes you have a situation where one spouse is not providing documents to the other side on date of separation and beyond about the business. That's a good reason. You have a duty to manage the business after separation. You have a duty to the other spouse to do that. If you fail in that duty, if you don't produce documents, that's a good reason to value a business on the date of separation. There's this inherent tension between 2552, which says you value on the trial date, and Family Code Section 771, which says that one's income after the date of separation earned is separate property. So 2552 tries to rectify that tension by giving us an option to ask for an alternate valuation date. Now, on the other issue that is very important and it causes many, many problems is when you have a business that was either acquired prior to marriage by one of the spouses and continued on during the marriage, or you have even a case where a spouse gets a business with separate assets. Maybe they get a $10 million inheritance. They take it, buy a business. So now you've got a mixed bag, a mixed characterization. So that's where you get into the good old Van Camp and Pereira cases. And in reviewing for this discussion, I found out that I forgot maybe that the Pereira case is actually an Alameda County case where I practiced and was on the bench. And the Van Camp Pereira issue is basically the issue Van Camp talks about, and just give me one moment. I'm going to just try to give everybody the bottom line of Van Camp and Pereira. And the bottom line is that in Van Camp, it gives a reasonable return on your investment But then based upon, this is a heavy, usually skill, that type of thing, small business. And so it gives a return on the investment, and the rest goes to the community. Pereira is the reverse, and that is where you have a situation where you give value to the efforts of the business, of the person that's running the business, and then the balance goes to the investment. It's discretionary with the court. They can even hybrid. Hybrid, there are cases that you will see that in fact do that. So that's a huge issue. There's a lot in the Van Camp Pereira issues about, I'm going to wait till it says that my internet is unstable again. But again, hybrids can be a basis of the valuation. So there's a lot of discussion about that in the case law. And that's what makes it so difficult sometimes in a case to come to a conclusion with the community versus separate. So I'm going to stop there and ask that you go to the next slide.
Okay, so double counting and spousal support. This is an interesting issue, and different states do things differently, but here in California, the courts are not as worried about double dipping as I think maybe they should be. So what is double dipping? Double dipping is when the valuation of the business has been subject to a multiplier of whatever it is, which is in effect taking the excess earning, taking the earnings and multiplying it over a certain number of years. And then that is the valuation of which half goes to the outspouse. Well, the in-spouse continues to work and then earns that money that was already paid out to the outspouse. Is that money to be considered money available for support? Or has the outspouse already received that money? I mean, there's an argument to be made that if an attorney has paid out to the outspouse the value of the business, then the efforts of that attorney in continuing to work should not, at least to the extent it's already been paid out, have to be considered yet again. Now, the courts are not as friendly to this as they could be and as they are in other states. But there's definitely an interplay between the business valuation on the one hand and 4320, which is the statute that determines the standards for determining long-term spousal support. And double dipping is something you could consider. And courts in California have been okay with double dipping, at least in the setting where it's not clear that future earnings were clearly the basis for the valuation. But on the other hand, a court could consider it as part of the gestalt of 4320, or even bury it in 4320 and make other findings if the court were troubled by it. My view is cases where you have the interplay and the risk of double counting are particularly good cases for mediation, because the parties can be pretty creative about the way they deal with the problem. And they can bracket their risk, particularly in this setting, because they can fuzz things in a way that a judge maybe wouldn't be able to. And my experience has been that unless there's real poison between the spouses, the reasonable outspouse can understand that the double counting is particularly unsettling to the in-spouse who has all the risks of the business and has already paid all those risks out and is taking them all. And if you do double count like that, you could incentivize an outspouse an in-spouse who is close to retirement age to retire rather than to have to work essentially all the time for the former spouse. So let's go on to the next slide.
All right, that's me again. And before I proceed, I switched for Pereira and Van Camp in my last statements to you. Van Camp is the case that's used of the method when the growth is due to market forces, Pereira when it's due to the labor intensive efforts of a spouse. So with that said, this is an interesting slide, perverse incentives and partner issues. This is something that unfortunately we see in family law a lot, and maybe it's in other spots as well. But the perverse incentives, first of all, torpedoing business or income manipulation. In a family law context, torpedoing business income refers to a spouse intentionally and deliberately manipulating a company's finances to underreport its income, which affects income available for child and spousal support, as well as lower potentially the value of the business during the division. So it's certainly out there. I'm sure all of us in family law, it's not are a stranger to that issue. So the common tactics for manipulating a business income, one is overstating expenses, where one spouse inflates the business expenses, maybe as I think Judge Landau mentioned already, paying for personal items such as vacation and cars. The other tactic is underreporting revenue, where the business owner may intentionally not bill clients, fail to record payments, not conceal or trying to conceal the actual income. I actually had a case one time where there was a witness that came on the stand on a business valuation issue and promptly provided both sets of books to the court, where there was a cash set and the other one was the set that you showed others. So that's another thing. Inflating liabilities, another issue. The owner may create or exaggerate certain liabilities that may not exist. The other tactic, manipulating bonuses. The business owner may delay or hold back their own bonuses or commissions until after the divorce is finalized. And then inflating salaries for friends or relatives. I've seen that issue a lot. You've got people coming in, oh, my son works for me. He gets paid $200,000 a year for sweeping the floors. It's done, unfortunately. It's a problem in valuing businesses in divorces. Hiding cash, who would do that? I've seen many cases where there's a lot of cash out there, sometimes actually under that proverbial mattress. And then misrepresenting depreciation, very common tactic sometimes as far as in an accounting. So that's the issue of torpedoing a business. I said before, it's a reason to value a business on the date of separation. And what can you do about it? Well, part of that is hiring a good forensic accountant that knows how to look into these things or to be aware. Judge Landau mentioned the next one, the sensitive treatment of a business partner and the dynamics of that. Treating business partner dynamics sensitively, in my opinion, is essential for a fair outcome that minimizes disruption and maintains business viability. The evaluation process can become intrusive, placing a significant burden on the divorcing owner and potentially leading to disputes with the other partners. I've seen it. I had a case, one of my last cases I tried were two brothers who were partners in a law firm, and there was a lot of problems. So there's challenges for those non-owner partners, as Judge Landau alluded to. When one partner divorces, the other partners can face significant disruption. They're in a forced partnership sometimes with the ex-spouse. There's operational disruption. There's financial strain. There's confidentiality risks, and there's damaged relationships. So those are all a problem in that business partner area. So we can go to the next topic. All right, this is a very broad topic with a lot there. And do you need an expert? And I'm going to indicate yes. I very rarely have seen a case where there's a valuation of a business where an expert's not needed. It can be done. I don't disagree with that. But I think, yes, you need an expert because, people normally can't value their own businesses. They can have, opinions, but I think you do need an expert. What expert, we'll talk about in a moment. When's the best time to retain an expert? My view is sooner the better. An expert coming on board at the beginning of the case can give attorneys someone to talk with, to gain guidance from, to maybe front load the case a bit. An expert can do not a thorough evaluation of a business, but there can be some initial work that the expert can do that would assist with that. So I think getting an expert on board is very important. I think it could actually be cost saving as opposed to increasing costs in the end run. It could start a dialogue between counsel and the experts in which settlement appears more of a likely event. What instructions do we give an expert? Well, there's, as you saw Judge Landau go through that one document, the instructions need to be, first of all, very clear. You want instructions that clearly designate and define for the expert the scope of the job. I'm sure Jennifer would always appreciate that, knows what the scope of her employment is and what you're going to do. And you want to make sure that the expert is given access to all relevant documents, including access to the discovery documents. And then you want to be able to give an expert key questions that are important for the assignment. So there's a lot of questions an attorney can pose to the expert. I won't go through them right now, but there are many key questions that one should ask your expert. Then have experts talk to each other. Judge Landau focused on this. That was always my pet peeve as a judge in family law. There were so many times, and I can remember very specific times where I would sit. One time I had both experts there at court. I told them to come into chambers with me and the attorneys. They talk together. They talk a different language than most of us do. By talking to each other, we settled the case. We realized that at that moment, there was a $30,000 difference in the valuation of a very high value business. So it is very important to have experts talk to one another.
Let me step in here for a second, Judge Pulido, because there was a question I saw in the question and answer. What do you do if an expert refuses to talk to the other expert?
I would ask the judge to order it.
Yeah, I'm not sure why that would occur. Usually when the forensics aren't speaking, it's because counsel's not giving them the authority to do so.
Right. Well, I think that it's a counsel issue. It's not an expert issue. An expert is not sui sponte going to refuse to talk. I think that at that point you have an issue with opposing counsel. And that's maybe someplace where you'd have the judge step in if you have to.
That's what I would say. And I agree. It's that would be surprising to me if it was a quote expert issue. I've never seen that, but I do see counsel that may be trying to be a little bit overcautious. And then last, the main thing is that I think when you have experts talking and some being cooperative, it does provide a clear understanding of the financial differences, and I believe the parties can negotiate more effectively or present a clearer, more focused case to the court. And the last one is the consideration.
Oh, it looks like we've been struck by Judge Pulido's unstable connection there.
A joint expert as well. So I like, we're getting my unstable again. Hold on.
We got you back, Judge.
We're here. So what I would say is this: consider joint experts either by agreement or not. You still have your right to your retained experts. So I will leave it at that.
We have a couple of minutes here remaining, and I wanted to throw it over to Jennifer on this slide about working with experts. What would you like our attendees, predominantly attorneys here, to know about working with an expert? What do you wish they knew?
I do agree. I think getting the forensic in early is more beneficial to the clients. We can help with discovery. We can really pinpoint what needs to be done, and we do sort of try to gear the case towards settlement, hopefully narrow the differences. But really, I think it's important for the attorneys to have a good understanding of what the scope is and what the instructions are. I cannot tell you how many times an attorney has said to me, well, what do you think the data value should be? Do you think it's a prayer, or do you think it's a Van Camp case? We can talk about the businesses. We can talk about the factors of what goes on in the business and what we see in the records, but ultimately those are legal arguments, and your forensic should not be providing that to you. The forensic should not be laying any sort of opinions that are argument based, and I think we see that a lot. So my suggestion to attorneys is just, talk to your forensics, have those conversations, but don't put that burden on them, because they should be independent. They should be providing facts to a court, not arguments. I've even seen forensic reports where they're listing out, well, my opinion is it's a Van Camp case. It's my opinion. I mean, that's not a forensic opinion. That's argument. So just making sure that you're talking to your forensic often about what's going on with the case, making sure that what they're seeing is jiving with your arguments. That's always great. Just making sure there's a good open line of communication often. So it's not just in the beginning, it's not just at the end, it's got to be happening as the process is going through.
And I think that's a good point, Jennifer. There has to be the open communication, and the attorney and the expert should be talking throughout, updating issues about value. And the other thing you said is extremely important. Forensic accountants should not be giving opinions on things that are beyond their scope. It's sort of like a custody evaluator making a recommendation whether there should be a move or not. That is not what a custody evaluator should be recommending, and that's not what a forensic expert should be saying, whether Van Camp or Pereira should be governing the case. They give the facts that support it.
And in our last moment here, Judge Landau, I wanted to throw it to you for any closing thoughts on working with experts as well.
One thing that is very useful in a mediation when there are experts involved is to have the experts available on Zoom, especially now that we have all the technology, and so that the expert can educate the mediator. The expert can potentially get in a breakout room with the other expert if they haven't consulted with each other. And the expert can even be part of a session with the other side explaining where they're coming from. Because most of the cases where I've had experts in mediation, the expert's presence has really helped to make clear what some of the issues are and whether one or the other experts has sort of missed something or made an assumption that turns out not to be accurate, in part maybe because the communication wasn't good or the data wasn't good or something. And so I think that if you're going to pay for a mediator, it makes sense, although I know it's expensive, to have your expert available. It's very helpful in the mediation to getting the case resolved, to be able to answer the questions with the experts in real time.
Thank you. Thank you. In awareness of time, I do want to let everybody know that we are at the 1 o'clock marker. If you do have to head out at 1 o'clock sharp, you will receive your full CLE credit. As soon as you leave the webinar, you'll be directed to a brief survey. We really appreciate if you take a few minutes to give us some feedback, let us know how we did today, and also your thoughts on any future programs. We always do read those and strive to give you content that you're actually interested in learning about. We do have a couple of questions here, and our panelists were generous enough to stick around for a couple more minutes. Your last question there, or comment there, Judge Landau, actually dovetails quite nicely. Somebody asked, from each panelist's perspective, when presiding over a business valuation issue, do you prefer live presentations or Zoom? And does CPA Magnes prefer presenting live or virtually? What are your thoughts about one expert testifying live and somebody else virtually? How do you feel about that?
I'll join in. Those who know me, I prefer live presentations. However, after doing 7 jury trials during the pandemic by Zoom, I understand the importance of it. So I do prefer live, but Zoom has its purpose, and I have no problem with one expert testifying live and another virtually. And I know that circumstances are such that Zoom sometimes just needs to be done. I'm fine with that, but my preference is always live in a trial situation.
I have a slightly different view. I'm kind of agnostic when it comes to experts. With live witnesses, I way prefer live testimony. With lay witnesses, I much prefer live testimony because you get a lot of cues from live testimony that you don't from a very small screen with just the shoulders up. But with experts, they are experts. They've testified a lot. They're very experienced at that, and they're expensive. And so having them come and physically be there live rather than just called on Zoom, I understand can be a real problem for parties. And so I'm agnostic on that. Whatever the parties think is the most useful way for them to proceed is fine with me. Jennifer, do you have a thought?
Yeah, I mean, I think as a witness, live is much better. For me, at least, I can read the room, especially in Los Angeles. We have a lot of newer judges, and so they are not as sound in a lot of these accounting issues. And so I can really sit next to the judge. I can show them where I am in my report. I can talk to them. I can see if they've got like a puzzled look on their face while I'm testifying. You don't really get that opportunity when you're virtual. So sometimes I can't even see the judge's face. We use LA Court Connect here. You can't even see anything. So, it's not as easy to see what's going on in the courtroom and read the room as you can when you're on the witness stand. And we're trying to give a lot of facts that are really difficult and really technical. And it is really important that we're able to do that. But with that said, it's not feasible in all cases. So if it's a really small issue, I think doing it virtually, really simple, really easy. If the case can't afford it, completely understand. Especially now, I think there's also the ability for you to be using witnesses that aren't in your location. So I'm getting a lot of cases now that aren't in Los Angeles, even though that's where I'm based. And they're not going to want to pay for my plane fare or my travel. And so doing it virtual makes it a lot easier and cost effective, and it's opening up the world a little bit. But there's nothing that beats live testimony.
Mm-hmm. And then our final question was a technical question, probably for you, Jennifer. Just, are attorney trust funds considered as part of the valuation if your client's an attorney?
Yeah, I mean, those will be on the balance sheet of the company, but it's basically a net zero. So it's going to sit in the cash account, the trust account. You're going to see a balance of an account, but you're also going to have the liability that offsets that for income not earned. So it's going to net zero. It should basically be removed. I mean, it's not removed, but it's just a net zero.
Easy peasy. Well, great. Those were the burning questions from our audience. I thank everybody for sticking around, and very much to our panelists for your time this afternoon.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services Inc.